Thank you very much, Anne. As you said, it's a second workshop we're doing this time. Last time we focused strongly on company foundation in Berlin. This time we'll rather talk about tips and tricks for the daily life of a startup business in Berlin, contracting, unfair competition law, marketing law, trademark law, IP law in general, especially, and employment law. Just a few words regarding the startup lawyers. I founded Startup Lawyers with my team 12 years ago in Berlin, and we're a firm really having a mindset like a startup, understanding startups. I think we're not just talking about it, we're acting like that. We are very fast and we love working for startups. Together with me today is Frido, who's taking over the company foundation wrap up, a short one from yesterday, from last time, not yesterday. We've been doing 5 workshops already this week. So we had another one yesterday for an incubator. And then the employment law part, and Kay is going into the IP law part after that. Yeah, maybe you, Frido, you say 2 words. Maybe you can do it when starting with your presentation. Thanks a lot to all of you. Very happy to have you here, and very happy to welcome you in Berlin if you're not already here.
Okay, then I will take over. Hi everyone, thank you for joining us today. I'm Frido. I've been a lawyer at Startup Lawyers for around about a year now. Have been a lawyer working in other firms previously, but I'm very happy to now be consulting startups from Germany and all over the world. And yeah, in that capacity, we're helping startups get their foot on the ground. We help them incorporating their companies, which was part of last session's presentation, and also advise them in their daily business, which will be the focus of today's presentation. And Kay, maybe if you could go to the next slide. I would like to quickly recap with you guys, for those of you who missed the session in March, what we talked about regarding setting up a company in Germany. Next slide, please. We talked about why one would need founding a company, and the benefits of having one. That is, hiring staff is a lot easier once you have a commercial entity that is conducting the business for you, and you don't have to act as you personally, and you are not personally liable. Getting a visa can be easier for those of you who are not yet in Berlin. That could be interesting, for example, for you as managing director of your company that you are founding. There is visas directed at that. And then lastly, you avoid the pitfalls of the so-called unlimited partnership, or Gesellschaft bürgerlichen Rechts in German law, which is a sort of implicitly formed form of corporation prior to the actual incorporation of a company. It happens as soon as you and somebody else pursue a common business purpose. That usually is what startups do prior to incorporation. And often that can lead to confusion about who's contributing what, and who is holding how many shares, and IP rights get messed up. And that is another reason why founding your company and having an actual legal entity, a structured legal entity with a articles of association, makes a lot of sense. Next slide, please. And then we talked a little bit about what the right legal form for your startups could be. Usually it will be, or in, I would say 99% of the cases for you, it's going to be a limited liability company. That in Germany is classically the GmbH, the Gesellschaft mit beschränkter Haftung. And the GmbH in the German corporate law has a so-called little sister, the Unternehmergesellschaft, which follows the same legal provisions as the GmbH, but has, for startups especially, the advantage of not having a share capital requirement of 25,000 euros, and instead can be founded technically with 1 share at the value of €1 already. The reasons why these limited liability companies, such as the GmbH and the UG, are so popular and so useful to startups, especially, is A, the market reputation. It is much better if you act through a commercial entity rather than as a single entrepreneur or the previously mentioned GbR. It's especially the GmbH has a good standing also with banks, simply due to the fact that a share capital of 25,000 euros has already been paid in and is there to be held liable for claims. It's also very advisable to have a limited liability company in terms of funding and financing. In our experience, investors look for this form of corporation, especially, or company, because their structure of investments is usually tailored to this type of company. And lastly, as I mentioned, you limit your own personal liability when founding a GmbH or an UG. You, as the founders behind your startups and companies, are no longer liable, and instead the share capital of the UG is liable for all contracts and torts and such. Next slide, please. Then we talked a little bit about the timing of incorporation, which generally you are free to choose, but as I've mentioned, there's a few reasons why an early incorporation can make sense for startups. It's a contractual partner for your service contracts, loans, and such. And later on, you do not have to transfer such contracts that you maybe as a person or an individual have concluded. You don't have to transfer those to your company later if you have the company early on to take on those contracts for you. It also enables you to early on transfer IP and trademark rights. We'll talk about those as part of today's presentation a little bit more in detail later. But it is a fact that rather than you individually working together with your starting team or your founder team, and each of you having maybe or bringing in individual IP rights, it is better for you to assign those early on to the company, and hence making clear who owns what in the startup. Lastly, by structuring your company and splitting up tasks and responsibilities, such as the managing director position, for example, but also splitting up shares, it helps you divide tasks and responsibilities a lot better and makes you aware of maybe what responsibilities are not taken care of yet, and therefore structures your company. Next slide, please. And then we looked at the characters or the roles in a limited liability company. That is, on the one hand, the shareholders. Obviously, those can be Germany-based or abroad. They can be natural persons or juridical persons, meaning legal entities, companies. You do not have to hold a visa to Germany. You can be anywhere in the world. For legal entities, this being juristische Personen in German, if you do want to incorporate in Germany, it's usually required that you have an evidence of existence, which is an extract from the commercial registry, for example, and you need power of attorney for those that come here to incorporate the company. And then you have the management, that being the managing directors on a UG or GmbH. This is usually or it has to be a natural person that can be based in Germany, but it does not have to be based in Germany. Usually the managing director has sole power of representation. That can be altered though. And sometimes, and we will talk about this in detail in a minute, there is problems with labor law if the MD is shareholder, the managing director is shareholder of the company, but maybe does not hold the majority of the shares anymore later on. I'll get to that in a minute. Next slide, please. Yes, and then we looked at the setup for companies. And on the one hand, you have the simple or basic setup. I did not put that slide in here. It is just founder ABC, like you see it here, and they as natural persons hold the shares to the company. On the other hand, you have the more advanced setup that we displayed here, where the individual founders of the company hold their shares through a, in this case, personal UG, so a limited liability company, which as a holding vehicle holds the shares to the operating company. This as main benefit has great tax benefits for the shareholders, because profits from the day-to-day business, as well as profits from a potential sale of the company, go into the holding company rather than going to the founders directly, and in the holding can or will be taxed a lot less. It's around 95% of the profits are not taxed, and this leads to you being able to use your profits a lot more flexible without them being taxed, versus when profits are paid out to a natural person directly, the taxes are usually much higher. Okay, next slide. And then lastly, we have a timeline of how an incorporation in Germany usually works. And that is, you gather all necessary documents, especially when founding from abroad. There can be quite a few documents necessary before you then move on to step 2, and that is the incorporation at the notary's office, where the managing director has to be present. The shareholders can be represented by someone holding power of attorney, but the managing director usually has to be there in person and sign his registration as managing director. Alternatively, he or she can do that abroad in a German embassy or at a notary there. After the meeting with the notary and the incorporation, you set up a bank account and you pay in the required share capital. With a GmbH, that has to be at least 12,500 on incorporation. Once that is done, you inform the notary's office that the share capital has been paid in, and the notary then files the registration of your company to the trade registry. And within usually 15 to 30 days, the trade registry will file or register your company, which completes this process. Yes, and I think that's it. Next slide. That was a recap of the presentation from last time. And before we move on to today's presentation, maybe if anybody has questions, we can do a quick Q&A session on this part. Otherwise, we can also, you can save your questions for later, but if you have any, feel free to ask now.
So if I may, I have just one question. Unfortunately, I was absent during the session on the changing of UG to GmbH. Then, and then as you briefly mentioned, so as per my understanding, I wanted to double check it, is that if you register UG, it means at the beginning you don't have to pay that capital, but with the passage of the time, the UG will be transferred to GmbH. once you have the capital? Was it like this?
Yes, the UG can be founded with a share capital of €1 up to as much as you want. And there's the technical obligation for the UG over time to put aside free cash and accumulate 25,000 and eventually transfer the UG into a GmbH. That's correct, yeah.
Okay, thank you.
Is there some disadvantage when we first found the UG and then go to the GmbH? Is there some disadvantage coming from this process? Some benefits that we miss?
Legally, no. It's they're basically the same from a legal point of view. It is more a question of market reputation, maybe. The GmbH, especially when conducting business with more, I would say, traditional institutions such as banks, still has a bit more of a reputable stand, as in mostly for the reason that you have a share capital which is much higher than that of UGs. But UGs, especially in the Berlin startup market, are very, very common, and I would say that at least 50% of our clients have started out as UGs right now.
So in terms of relationship to investors, I think like investors are more relevant for startups rather than banks, right? Because it's mainly venture capital rather than loans. So for investors, does it represent any kind of challenge or like reputation damage that it's UG and not GmbH?
No, legally it's the same, as I said, and the investment can be carried out the same way. Shares can be acquired the same way. So for the investor, it should not play or not make a difference. No.
Okay, great.
Any other question? Otherwise, we go forward. Yeah, Sefer Mahmoudian.
Yes. Can you hear me? So
yes.
I have a question. If you have in the structure that you showed, if you have a GmbH that owns another GmbH, but the parent GmbH, you are the 100% share owner of that. But if something happens to that, let's say under that you buy other assets and it goes bankrupt or some other legal problem happens to it, does it affect your real startup, or are these two completely isolated?
No, I mean, if the shares are held by the parent company, then of course the shares go with whatever way the parent company goes. So I don't know if they were seized or, for example, transferred as part of the deal, then that affects the daughter company as well. Or did I miss something in the question?
I mean, yeah, that's the answer. But let's say if the parent company is audited, nothing happens to the sister company. Is that correct?
I mean, I guess it would depend on the type of audit and what one's looking for.
Mm-hmm. Right. So this is a generic question. Maybe we can go on.
Yeah.
Thank you. Okay, if there is no any other question, then yeah, Frido, please.
Okay. Then we'll get started on the first part of today's presentation, and that is the basics of contract and employment law. First of all, contract law, what is it and where can it be found in German law? To start with the very basics, it's there's no such thing in German law as contract law. It's rather can be found in this beautiful book that I showed here. It's the Bürgerliches Gesetzbuch, the German Civil Code, which has an overwhelming amount of 2,385 paragraphs, which is this little sign down there, and paragraphs in this case mark the individual law code. And scattered all over this German Civil Code, you have provisions that stipulate contracts that you conclude every day as startups in Germany. Next slide. As I said, yeah, there's regulations all over the German Civil Code. Some of these are found in a general section where general provisions such as the form of a contract are stipulated, and then there's more specific sections in the German Civil Code where the most important type of contracts such as sales contract, rental contract, service contracts are regulated specifically. And then on top of the German Civil Code, you have the German Commercial Code, the Handelsgesetzbuch, and for special fields of the law, such as employment law, you have a number of other special laws that add into the regulations or sometimes overlap or specify the German Civil Code. What might be interesting for those of you that only speak English and no German, the German Ministry of Justice publishes English translations of the most important German laws, and in particular, the Bürgerliches Gesetzbuch. So if you're curious to read up on rental and sales contracts, service contracts, etc., you can do that under this link. And I believe that the slides will be shared as well in addition to this recording. So you do not need to write this link down. It will be shared with you later. Next slide, please. To briefly talk about contracts and how they're structured, you have, I would say, two different ways a contract is often concluded, and that is one, an individual contract document where maybe the parties even negotiate different parts and attach annexes, and at the bottom you sign wet ink or via a DocuSign or something. And then in what you have more in quick e-commerce and day-to-day business is often a short order form that stipulates in case of a sales contract or service contract, what type of service or good is purchased, and then what's referenced in the order form are the applicable terms and conditions. That is in German, the allgemeine Geschäftsbedingungen, and then sometimes you have annexes. And these terms and conditions is then usually what actually is or forms the contract. And here you have a picture of how it usually looks when you conclude a contract online. You have a link to the general terms and conditions where all stipulations that the salesperson or whoever you conclude a contract with usually uses for their businesses. Next slide, please. And then to quickly talk about forms of contracts. So in what form does a contract need to be concluded? In German law, we usually have the freedom of form, Formfreiheit, meaning that contracts can be concluded in a lot of ways, orally or in writing, but also implicitly. A good example for this implicit contract conclusion is the common venture, the GbR, or unlimited partnership that I mentioned initially. That is often formed without an actual agreement by the shareholders or founders. Simply by working together, they express their will to form this, and then in the eyes of the law, it will be regarded as a valid legal form. But there's, of course, exceptions to this freedom of form rule, and in the German Civil Code, but also in other laws, you will find that the written form is required for certain legal acts and contracts. The written form, that's wet ink signature or the qualified electronic signature, and that is mandatory, for example, for the termination of an employment contract, also the termination of a lease agreement. It's necessary if you want to conclude a limited term employment contract or a limited term lease agreement. And the consequences, if you do not follow these form requirements, is usually that either the contract is not valid or the legal act, such as termination, is deemed void. Now, in the case of the, moving on. Thank you, Kai. So with that said, we move on to a particular field of law, which is employment law, that most of you early stage founders will be facing or have faced maybe already. Employment law is very important, obviously, for young businesses, because at some point you're going to wonder, should I hire an employee? Should I hire a freelancer? And the first question that you may ask yourself when making this decision is, what's the difference between employment or an employee and a freelancer? And that is, the definition of a freelancer would be someone who's essentially free to organize his or her own work, free from direction, and determine his or her own working hours. On the other hand, you have the employee who is obligated to perform work in the service of another person, of another in personal dependence and under the direction of others. Now, this dependency and direction that the employee is subject to, it comes with a lot of benefits as well. Under German law especially, you have the Kündigungsschutzgesetz, so protection from unrightful termination. You have the Entgeltfortzahlungsgesetz, which stipulates the right of employees to continued pay in case of sick leave, for example. You have the Bundesurlaubsgesetz, giving the employee a right to a minimum amount of vacation days per year. So those are the two types of people that are broadly you may have working for you. And one important thing that we would like to make you aware of when hiring freelancers, for example, is the pitfall of the so-called Scheinselbstständigkeit, translated loosely maybe as bogus self-employment, meaning that someone working for you is maybe on paper a freelancer, but in reality, he or she is an employee. That is, it can lead to the company being financially liable for social security payments that need to be made or taxes that need to be paid on the remuneration that you're paying your fake freelancer. And worst case, it can also lead to a criminal liability of the managing directors of the company if social security is wrongfully not paid. Now, next slide, please. Yes, that one. To go into detail about Scheinselbstständigkeit a little bit, just to make you aware of this being a risk when hiring freelancers. What the authorities in Germany do, and that's the Rentenversicherung, they do a so-called Betriebsprüfung, where they review your businesses within 5 or 10 years, usually from incorporation, and they will look at employment contracts, they will look at freelance contracts, they will look at the payments you've made, and based on a number of factors, some of which I've listed here, they will determine whether or not somebody was actually a freelancer, or maybe if there's indication that a freelancer was in reality working for you as an employee. And it's unfortunately not a black and white decision. It's always a number of factors that the authorities will take into account and have to weigh against one another. But usually it's factors such as the rights to issue instructions, so meaning that the employer has the right to, or the principal on paper issues instructions to the freelancer, is very involved in determining in how the work is carried out and sort of micromanaging. Then you have the integration into work organization, which means that the freelancer may be working in shifts, or maybe working on site a lot more than necessary. They will also look at the bearing of the entrepreneurial risk. So is the freelancer even acting as an entrepreneur, or is he maybe so dependent financially on this one principle that he doesn't actually have an entrepreneurial risk as long as he is paid by this company? Is he free to allocate the time, so do tasks at their own will and at their own time? Are they integrated into shift plans? And is there maybe a continuous remuneration in the form of a salary? Is there other principles? So is the freelancer working for other companies as well? Is the freelancer granted leave? So maybe even actual vacation days. And is the freelancer maybe even using company email addresses, telephone connection? Does he or she have their own office? And lastly, one strong indicator is also if this activity that the freelancer is carrying out has previously been part of an actual employment relationship. So this is just a sum up of the criteria that plays a role in determining whether somebody is working as a freelancer or maybe actually a employee. Next one, please. And this so-called Scheinselbstständigkeit or bogus self-employment is something that you can also occur, or that can also occur in the context of GmbH or UG managing directors, because managing directors usually are employees of their company for as long as they don't hold the majority of the shares. If they do hold the majority of the shares, which is often the case with young startups where maybe a founder founds the company on his or her own, or with a partner, but maybe holds the majority of the shares and is also managing director. In that case, usually he or she will be regarded as self-employed due to the fact that he or she actually controls the company with a majority of shares. Now, what can happen over time is that when shares, the share load of the managing director through investments, for example, dropped below the 50% mark, and therefore the managing director no longer controls the organization in the eyes of the authorities or the Rentenversicherung, the managing director then becomes an employee, meaning that any payouts, any profits, dividends that the managing director is paid will be regarded as, or can be regarded as salary, and would then be subject to income tax and social security payments. So that is something to keep in mind and maybe check from time to time. Next slide, please. Now, when we look at contracts that you may be concluding with employees or freelancers, what should be included in them are the absolute basics, and that's, for example, the work time should be clearly stated. For employees, that's usually in hours per week. You should state the vacation days. That's a minimum 20 days for a full-time employee in Germany. You should state the probation period during which a termination of the contract is easier. That's usually a period of 3 to 6 months. You should state whether it's a fixed term or long-term or permanent agreement. And then something that's very important and that we stress in every workshop that we do is make sure that you have a comprehensive transfer of IP rights clause, making sure that your employee or freelancer actually transfers all the relevant IP rights that he or she is creating for you to the company, and that you have all the rights necessary for your business. And lastly, obviously, the remuneration salary should be clearly stated. Next slide, please. Then a few more things on employment and freelance contracts. Although, as we learned, the written form is not always required, we highly recommend putting all these contracts with the necessary clauses that I just mentioned in a written contract. It is possible that you incidentally or orally agree on an employment contract. That can happen, but it is absolutely advisable to actually put the whole thing in writing. For something such as limited term employment, as mentioned before, it is legally required. And then if you do not put this limitation of the term in the employment contract, what will happen is that your employment contract will be regarded as unlimited, making it a lot harder to terminate the contract usually. And lastly, an advice from me on templates that you're using. Bear in mind that labor law in Germany is constantly changing. We have a very active federal labor law court. And that's why it's very important that for freelancers and employees, especially, you use an up-to-date and good template, and not just use any random document you find on the internet that often aren't even designed for our jurisdiction. Next slide, please. Lastly, just a few things that you may or you should have heard about in the context of employment law. There's a minimum wage in Germany. Currently, it's 9.38 or 82. I'm sorry, 9.82, €9.82 before taxes. It's going up to 12 euros in October, and that needs to be paid to all employees as well as interns, unless they're students. There's a few exceptions, but generally to most employment relationships, the minimum wage law will apply. There is something called the Kündigungsschutzgesetz. I mentioned that one earlier before. It's the protection from wrongful termination, and this law applies to all companies above an employee threshold of 10 employees working over 30 hours. And when the Kündigungsschutzgesetz applies, to put it simply, it means that termination of contracts can usually only be done when socially justified. So there will always be a weighing of interests on the employer side and the employee side. We have minimum vacation days. It's usually 20 days for a full-time employee working 5 days a week. There's something called the Anti-Discrimination Law, the Allgemeines Gleichbehandlungsgesetz, AGG, which applies to a lot of circumstances. It's not just the employment relationship, it also applies, and especially applies to job openings, for example. So if you're hiring, make sure that your job profile is not discriminatory. For example, if you were to hire someone only below the age of 40, that can be a discrimination which allows for those that are discriminated because of age, in this case, to even file for compensation. And lastly, in the context of employment relationship, what's interesting and what can be a good way for binding employees to your company if you are maybe if you don't have the funds yet to pay high salaries, what you can do is give out on top of the salaries a so-called virtual share option plan, or VSOP in short, which is, to sum it up briefly, a program where you give out virtual shares and not actual shares to your employees, which are vested over time, and at the end, in case of an exit, can be transferred into a claim. So the employees get a share in a profitable exit by the startup. Okay. And with that, I would like to hand over to, or maybe we do a quick Q&A session here. Huh?
We have actually already one. Bente, do you want to ask by yourselves? Because I'm not sure I'm getting right what you wrote down. I don't know if you're still here. Bente Nijus. I can see it. I can see him in the gallery. Oh, yes, he or she's still here, Bente? Yeah, I'm here, but not, I am in the position to speak out loud. Okay, so maybe we are trying out. So the question of Bente, what's the standard for the bearing of entrepreneurial risk and how can a company check this? Of course, it is hard gauge a freelancer standard of living. If we would hire them, for example, 24 hours, we may consider them to be a freelancer, whereas they are comfortable enough to subsist on what we pay them. I don't get it, but maybe you, Frido?
Yeah, it's very difficult, as I said, to give exact answers on these questions because it always depends on the circumstances and a lot of individual factors. But you are generally not obliged, of course, to check for every other employment that this person has. What you can do is put in the contract a clause saying that the contractor is not solely employed for you or not solely working for you and has other principles. You may also add that he or she is not financially dependent on you. But of course, if you are reaching a number of hours that is close to that of a full work week, then that can be a strong indication that there is no other contractors. But it depends on the circumstances. It could be that a contractor works for you for a week or two on a project, and if you have a sort of a crunch time, then it can be necessary that he or she works for you in a lot of hours. That doesn't necessarily have to mean that there is a financial dependency or that he or she does not bear the entrepreneurial risk anymore.
Okay, I hope it answers the question. Yes, thank you. And Matula, you raised your hand.
Yes, my question is about the employees who are not, let's say, in Germany. The company is in Germany. For example, you have 1 or 2 persons based in Germany, but then the rest of employees, let's say 7 to 8, you recruit them and they're based in some of the Asian countries. So are we supposed to follow the minimum wage based in Germany, or we are supposed to follow the minimum wage which is in their own country, which is of course different than Europe?
You are the employer.
Yes.
And they're employees. They're not not freelancers.
Yes.
Do they have a German employment contract under German law?
I mean, it's the something we are going to do. We didn't do it, but they are based in their own country. So, but the company is registered here. So we want to register them. So are we going to do it based on the German law or their own country law?
This is really a question that depends on so many factors.
Okay.
It's rather the location where they are based. So
Okay.
in general, German minimum wage law does not apply for someone developing software in India.
Okay.
But there may be exceptions, and especially this really depends on the contract you have with them.
Okay.
You won't pay social insurance for them, no?
No.
Well, and this would also not really work. So it may not really be an employment contract in terms of having an employment. Rather, how do you pay them, per hour or?
No, per month, but they're not physically here.
Hmm. And do they ever come to Germany, or the only connection is via online meetings and so on?
Yeah.
Yeah, it depends on the contract, but in general, there's the German law is not applicable to such a situation.
Okay. Thank you.
Okay, Jakub, you raised your hand as well.
Yes, I want to ask about the combination of these two topics together. Basically, you mentioned that if the co-owners or co-founders of the startup have a UGA for their person, especially like one company that sort of is owning the shares in the startup, then they can get some benefits from that. And my question is like, if it's possible then for them to be self-employed in this situation, in the startup, and if it's like a usual way how to treat this problem with yeah, what are all the aspects of this situation? Basically, like you wanna not tax profits, you wanna pay yourself money without having to be employee and do all the procedures that are required for that. Like if you could like comment on the benefits of this setup.
So what you're asking is whether this differentiation between self-employment and being an employee as managing director also applies to the setup where the shareholder and managing director has the shares in a holding company.
Yes, yeah. Yes, it would be exactly this setup as you mentioned. And my question is, what are the benefits of this, and if it's a common pattern, how to deal, because basically you mentioned that you can only be a freelancer in your own company in this UGA that will hold the shares if you own more than 50%, which is the case here, right? So I'm asking, like, is this a common setup, and what are the benefits?
Well, first of all, to make this differentiation between self-employment and being an employee as managing director, it makes no difference if you hold the shares as a natural person or if you control the shares through a holding vehicle, because for as long as you assert control in the operative company and be that through a holding company, you would still then be technically a self-employed because in control managing director.
Yes, but I'm sorry to distinguish. What I mean is a setup where you have like 3 co-founders and everyone is holding a third, let's say. So it's not more than 50%. But since everybody has his own UGA, he's 100% owner of that UGA which holds his shares in the startup. That's the setup I'm talking about.
Yes. Are you talking about tax benefits or corporate law benefits, or is this an employment law related question?
Yeah, so okay, I get you, but because basically even if you have this UGA that holds where you hold 100%, which holds your, let's say, a third of the startup, then it doesn't mean that you get paid for it, right? It's not a vehicle for getting paid a salary, right? Or could it be? Could you? My question is, can I basically get rid of the obligation to be employee if I hold a third only by doing this setup? Being
it's the 100% that you own in the holding vehicle don't play a role because they will only look at the operative company where you are managing director. And if you, be it as a natural person or through your holding vehicle, only control 30% of the shares of the operating company, of which you are managing director, then you don't effectively control it and would then usually be regarded as a so-called Fremdgeschäftsführer, and that is an employee situation.
Right, but let's say like there is no way how to do this. Like I was thinking, like for example, I could distribute the profits that I earn through these 3 UGAs that all of the co-founders own, and the profits would be taxed in some way, but it would be less than typical salary. And I could then use these profits to pay myself some wage, right? As a self-employed person in my own UGA.
No, actually, that's not working. That's the setup we described. If you don't have more than 30% in the shares and you pay out yourself part of the profit as a salary or whatever you call it.
No, not as a salary. I pay it as
but whatever you call it, you pay it from the company's bank account to your account, and this is not only taxed but also subject to social insurance. That's exactly the setup we are talking about, and it's not avoidable if you only have 30% of the shares. You can only avoid that and with not paying you any money out.
But I mean, I can definitely get like a profit from the startup to my own UGA, right? And then it depends on me if I actually use that profit to pay myself a salary or some kind of fee as a freelancer, right?
No, there's a misunderstanding, because if you pay yourself a salary, you don't use the profit to pay a salary, because the profit is what stays in the company after having paid all the salary and all the costs. But when you see that there will be 30% left or profit, like 30,000 euros profit at the end of the year, and you pay out to you, let's say 1/3 of it, 10,000 euros, no matter how you declare it, this payment will be subject to 25% additional social security.
Mm-hmm. Well, I mean, it's a profit for the startup, but for the company that owns the shares in the startup, the third, it's income, right?
That's correct. Yes.
Yeah. So it's not profit. It's income that I have that I can spend. It's like free cash flow. I can spend on anything I want, right? So I can either pay myself a salary or whatever I want.
Yeah, I think we turn around in circles here.
Okay, it's okay.
Maybe,
thank you.
Yeah, maybe we go on because of the time.
Yeah.
Sorry for that, Jakob.
Sorry. There is still a question, maybe very quick. Sefer Mamoudian, do you want to just share your question with the guys? You're still here?
Yes. So the UK has to become a GmbH. Is there a time limit on this? There are 3 questions actually, but this is the first one. Is there a deadline? 5 years, 10 years?
Not at all. There's no obligation. The only thing is, like, when your UG never has significant profits, then it will never turn into a GmbH, and there's no obligation. It's just like that the part of the profit, 5%, have to stay into the company, can't be paid out at the end of the year, and by this deposit, let's say you increase constantly the share capital up to the amount of 25,000 euros. And that can happen very quickly. if you have a profit of 100,000 euros in the first year, then it will be automatically, not automatically, but it has to be transformed into a GmbH then by having a notarized capital increase, and then it turns into a GmbH. Or it can happen years later or never, in case you never have significant profits.
So if you want to make a growth company and you just want to reinvest all the profits, no dividends or anything paid out, you just keep raising seed round, Series A, and anything that any revenue gets reinvested in the company, then it can remain a UG forever, basically.
We have clients with very high million revenues per year for many, many years, and it's still UGs. Yes.
Thanks a lot.
Okay, cool. So thank you very much for the question and then for the answers. And we can go on, I think, with Kai, right?
Yes, so I'm Kai. I'm already with Startup Lawyers for 8 years now, and I mainly deal in trademark law, copyright, and unfair competition law. And yeah, so today we take a look at IP rights, which are intellectual property rights. And as you can see, we mainly are dealing with trademarks, copyright, patents, design, know-how, and to some extent domains. And going on, we will focus on the IP rights, which in my opinion are most important for startups to have them on their mind. And the first one we will talk about will be copyright, because it is unfortunately very, very easy to infringe someone else's copyright and get into legal trouble because of that. Then trademarks, which are of course very important in building and defending your brand. And in the end, we will take a quick look at domains. You know, what are their, what are they legally? Are they even a property right? But they are nevertheless very important, as you want your domain to align with your trademarks, with your brand, so that people can find you, can find your online presence. And with that, let's start with copyright. Copyright applies to any human-made output embodied in a tangible or non-tangible form that achieves a minimum degree of creativity. This means that anything you create, let's say you create a picture, a drawing, a text, a song, or a melody, or something like that, if that is not just some basic scribble, like today I went to the supermarket and I bought some food. This is a text. If you write it down, this would not be copyright protected. But if you take the thought of going to the supermarket and buying food and put it into a story filled of anecdotes and poems and other stuff, then because of adding these parts of creativity, you could have a work that is protected by copyright. There is one major limit to this, though. Copyright does not protect ideas. So this means I am not prohibited from writing a book about a small boy attending a wizard school and ultimately defeating the evil overlord who does not have a nose. But I may not use the characters of Harry Potter or copy exact details of the story. The same is true, for example, for cooking recipes. If I have the best idea for how to make hummus, it's not protected. The ingredients that I use and the ways I do it are not protected. And as long as anyone copies this recipe, I cannot do anything about it because it's just an idea. Recipes are just it. So, but apart from this, from the limitation of ideas not being protected, it's very easy for something to be copyrighted because the limit, the threshold of creativity you have to achieve is not very high. And you may ask yourself, how do I get copyright? Do I have to file an application? Do I have to register it somewhere, or do I have to pay a fee? No, you do not have to do that. All you need for your copyright to exist is to actually create the work, be it a text, song, picture, whatever, and have it be creative enough to be regarded as a copyrighted work. And from the day of creation, there exists copyright protection, and the term is life of the author plus 70 years post-mortem. So this means that the copyright right now for works of authors who died on or before 1952 is expired, and you can freely use it. So, you know, famous painter died 1800s, and you can find his pictures on his paintings online. You can use them for your, you know, marketing campaigns or whatever. There would be no problem, but it would be a very bad idea, not a very good business case. For example, to sell copies of the famous Le Corbusier chairs and sofas from the Bauhaus area, since the creator, Le Corbusier, died 1965, which means at 70 years, that the copyright will expire only in 2035. So if you were right now to try to sell those chairs, you would be sued to the ground, but wait 13 or 14 years more and you will not have a problem doing so. And yeah, under German law, certain personality rights in copyright are non-transferable and almost non-waivable. This is in the day-to-day life not really an issue, because the rights that you need to use copyrighted works of others, the so-called exploitation rights, they are transferable and you can buy them and you can transfer them. So, but it's always, there's some corner cases where these really personal copyright rights come into place, but this will not be the focus of today. So in order to handle copyrights in your company, it's very important, if you are of the opinion that you want to use a work that might be copyrighted, to secure all copyrights to the company that wants to use it. And typically, you go to the author and you close a contract with the relevant author and try to get all the rights that you need. You know, be it the right to display the work online, to use it in your advertisement campaign, or yeah, whatever you need, you know. And it's very important, or quite important, to note that copyright and ownership of a copyrighted work of art, for example, are not the same thing. So if you buy an original painting, for example, that is still copyrighted, let's say because the painter is still alive, and you just buy the painting and you have it in your hands, and you do so without securing any exploitation rights, then you are not allowed to show pictures of the painting that you bought, that you own, online, or to use it in your advertisement campaign, because, you know, ownership of the painting itself is different from the copyright. So and to you it might sound like, yeah, this is a very corner case, you know, I do not intend to buy paintings and then use them in advertisement campaigns, but problems arising from the distinction between ownership of a piece of copyrighted work and the copyright itself, they happen more often than you think. For example, a client of ours who specializes in individual furniture, yeah, they set up a new table in the client's kitchen, and then they asked the owner of the kitchen or the house, is it okay if we take photos, you know, from a nice table? You have a nice kitchen, we can use them in our online catalog. And the owner said, yeah, sure, it's no problem. So they took the photos and put them online, and then they received a letter from a painter who said, you are violating my copyright, because in the background of the kitchen, or there was a painting on the wall. And so without having secured the copyright for the painting in the background, it was illegal to use the photo containing the painting. And a similar case happened just a few months ago, where another client of ours used a photo of a hotel spa area. Again, the hotel was fine with it. They said, yeah, use it for your own advertisement. And the problem was that the hotel spa area had a photo wallpaper in the background, and the photo was also copyright protected. And then the photographer came and claimed to take down the photo, because his work, his photo that was on the wallpaper, has been used without securing the copyright, and rightfully so. They were all correct in demanding taking this down. So again, it's an example of how easy it is to get into conflict with copyright, even if you're not even, thinking about it, and you think you have you have cleared all the rights with the hotel or the owner of the kitchen, as in the case before. But yeah, you have to be very, very alert about this. And so in order to secure copyrights, you have to make a contract. And in this contract, you cannot write, I am allowed now to use this work of art for everything. Just I buy out all the rights and now I can do everything I want with it. Those contracts are void under German law, mostly void under German law, because they have to be detailed. Yeah, you have to say, I want to use your picture, song, whatever, in my advertisement campaign. This is online, social media, in print, books, in catalogs, and you have to, all the things you want to use it for, they should be listed. And as you can already see, it's best to use a lawyer to do to set up those kind of contracts, because there are so many errors one can make that would make the contract void, or so it's always good to involve lawyers with this. Another point that has to be in the contract is equitable remuneration, because artists and authors should be paid equitably. And there is one famous case going on right now, which is the cameraman of the famous German movie Das Boot from the 80s. And he's suing the production company for extra remuneration, because he says this film was so successful, and partly because I was such a good cameraman, and now he wants more. And he is getting more. The right amount of how much he's getting is still up to be decided by the courts. But it is also something that, if the copyrighted work you use is very successful, then there might be some demand for further payment. And again, we cannot stress this enough: do not use copyrighted material without authorization, because not only can third parties who are owners of the copyright stop you from using the material, so that would mean that you have to take down your video or your catalog, or change your website, but they can also claim the costs that incurred for hiring the lawyers to send you the cease and desist letter. So again, it's not only a matter of you having to change your advertising materials, but also being financially, you have to pay for the cease and desist letter if you get one. And the most common defense is, oh, I didn't know that there was a copyright, and how could I have known this? It's not going to work, because as soon as you post or use the copyrighted work, the saying goes, you should have checked beforehand if you're allowed to use it, if it's copyrighted material, and if you do not do so, you are liable for using it without asking. So yeah, so the takeaway regarding copyrights would be: check everything you want to use if you've made it yourself, or if it contains copyrighted material. And if you think it might be copyrighted, try to get in contact with the authors and secure the rights so that you can use it without worrying. But yeah, even the big companies, they make mistakes and use copyrighted material without knowing and get in trouble with it. So do not feel too bad if you happen to violate one or the other copyrights in the next years. But it's better to seek lawyers' advice if you're ever in doubt. So, and the next intellectual property right we would talk about are trademarks. And trademarks, I think everybody knows what they are. Everybody knows the Coca-Cola sign, or the Apple, or all those kinds of signs that are put onto wares and whatnot. And there are different kinds of trademarks. So we have a word mark, which is just plain words. Then we have a figurative mark, which are most of the logos. Then figurative marks containing word elements, like a logo containing the name of the company. Shape marks, position marks, pattern marks, and sound marks. And I suggest that we take a look at a little overview Is this working right now? I tried to open this link, but it's not letting me do it right now. So anyway, I was going to show you a little overview from the European Intellectual Property Office, where they showed you, word marks, Adidas, Volvo, and so on, and then figurative marks, which would be the Reebok slashes or the 3 stripes of Adidas, and then combined marks, which would be the old Fujitsu logo, where they have this little swirl up on top. And yeah, but I think you all get the idea what trademarks could be. And yeah, and just to the takeaway from let's go back once from all the different types of marks is the most important ones, and nearly 100% of trademarks you want to file will be word trademarks, figurative marks, and combined trademarks. The other ones, shape marks, position marks, pattern marks, sound marks, they exist, but yeah, you do not really need them. They have very special use cases. So word mark, figurative mark, combined mark are what it's usually about. And you do not need a trademark to sell a product or offer a service under a certain name or logo, but it's strongly recommended to do so, mainly because you can block others from using your company or product name if you have a registered trademark, and you can protect your own company from the risks resulting from infringing earlier marks or names of third parties. So the first point would be, if you register the trademark Adidas and you sell shoes under the name, and 5 years from then, a third party also wants to sell shoes under the name Adidas, you can stop them from doing so because you have the trademark, and yeah, they don't have any right that is older than your trademark. And if you were to start selling shoes under the name Adidas without having a trademark, and then 5 years from now, somebody trademarks the name Adidas and also wants to sell shoes, then he can actually stop you from using the name Adidas, even if you've been there 5 years earlier, but you do not have the trademark, you do not have the intellectual property right behind you. So yeah, you would be looking into the hole, and you would have to change your name because you did not secure the trademark rights that you would need. What can be registered as a word trademark? Basically, it can be any word. It just has to be, in some kind of alphabet that is eligible or legible. And the minimum requirements are distinctiveness. And distinctiveness is the ability of a trademark to distinguish the goods or services of one company from those of another company. So words lacking any distinctiveness would be, for example, great or beautiful or soft. Those are just, attributes or things. And nobody would think when they read the name beautiful that this belongs to a certain company, because, everybody would use the word beautiful for in their advertisement or in their daily language. So it's they would not be distinct enough because nobody would think even that there could be a company behind it. And also trademarks like beautiful flowers, they could never be registered for selling flowers. And the same is true for elegant, for selling clothes, or for best payment service provider for payment service providers. So you get what I'm getting at. It has to be distinctive, and examples for distinctive words are delivery hero, for example, even though it's on the edge because, delivery hero, if you use it for delivering food products or other stuff, it's kind of descriptive. But it's still enough. It was good enough that the trademark offices let it go through. And yeah, other examples that are no questions asked distinctive are for Zalando, any fantasy name that doesn't really have any meaning in the real world has distinctiveness. And Yeah, so you are basically fantasy names, you are on the safe side regarding distinctiveness, and the closer your trademark, goes to being descriptive or being too just beautiful words, then you might have a problem with your trademark not being distinctive enough. Further requirements are no violation of good morals. This seems a little odd at first sight, and it is mainly not a problem if you want to register a trademark, because Zalando, Adidas, and they all have no elements where you could think, oh, this is this goes against good morals. But a very recent example of a trademark being refused for being against good morals or violating good morals was "Fuck You Goethe," which is a German movie from 2015, and the European Union Intellectual Property Office, which is responsible for EU trademarks, it actually said no, because it contains the words "fuck you." This is offensive and vulgar, and we will not register this trademark. And production company of the film then sued against this decision, and the first instance court still said no, "Fuck you" it's a no-go for our trademarks. We do not want that. And it took the last instance court, the European Court of Justice, to rule that "Fuck You Goethe" might be provocative, yes, but seeing it in the context of the movie being funny and so on, they said it's still acceptable. So provocative is good, but violation of good morals is not allowed. And sometimes you have to fight many years. It took them, I think, 5 years to get their trademark registered. So it might take a lot of time. Then we have formal requirements and fees. The formal requirements are mostly met by using the forms provided by the trademark offices. If you check all the boxes, if you enter all the details, then those should not be a problem. Regarding fees, they have to be paid. The amount of fees we will talk about later. And a very major and very important point is that there are no earlier identical or similar marks. And as we've seen before, one of the purposes of registering a trademark is to block others from using it. And this includes others registering identical or similar trademarks. So if I, try to register a trademark, and there is a third party with an older trademark who thinks, I think your new trademark is too close to my old trademark. They can file an opposition against my trademark, and then the trademark office has to decide whether my new trademark is similar or identical to the old trademark. And if it is, then my trademark will be deleted, my new trademark that I just paid all the fees for and had all the naming process. And only if the trademark office finds no, they are not similar, then the process of registering the trademark will go on, and I will not have a problem. So this makes it very important to do your research before deciding on a name and registering it as a trademark. This is really, before investing any money into this sort of stuff, you should do your research or let someone else do it for you. And that's very important.
Kai, sorry to interrupt. We only have 3 minutes left, actually.
Oh, wow. Yeah, then I will try to be as fast as I can. So trademarks, you cannot just apply for a trademark and then it will be worldwide valid. So the time, it starts from the day of application, and then you have 10 years. You can renew it indefinitely, there's no problem. Territory, you can only apply for trademarks in certain territories. If you apply for a trademark in Germany, it's protected in Germany. If you apply for it in the European Union, it's protected in the European Union. And you have protection only for certain goods and services. So there's a nice classification of 45 different classes. And you have to, pick your classes that you want and the goods and services that are in there, and then put together a trademark application based on this. And the costs for 2 classes for European application, which covers all European Union countries, is 900 euros, and every additional class costs 150 euros. Germany is much cheaper. You can get a German trademark for 290 euros and have 3 classes included. At this point, I wanted to look with you at all the classes that are there and what are the most important ones. But since we're out of time, we just yeah, we have to skip that. And a very important point, which you can see on timeline, the last one is watch out for fake invoices. If you apply for a trademark, it will be published, so the public will know. And then fraudsters like to send you invoices and saying, yeah, I'm the official trademark office and please pay me. Do not pay those invoices ever. Just, if you file it through a lawyer, only pay what the lawyer asks you to and ignore anything else. And if you want to check for yourself, you can go to the Trademark View website of the European Property Office and check for available trademarks. You should do a Google search, for the name you want to register as a trademark and see if anyone else is operating under this name. And step 3, the TM class. This is the service I just told you about, where you can check all the different goods and services that are available and in which class they fall. So we will send you the slides, and then you can, take a look at the sites and perform the searches on your own. And last but not least, internet domains. They are not really a property right because you do not own them per se, but you, if you buy a domain, you enter into a license agreement with the local domain office. And general principle is first come, first serve. So if you see a domain is available, you buy it, it's yours. You are then allowed to use it. And the only exception is that absolute rights like trademarks prevail. So if I happen to be the owner of the German top-level domain apple.de and I sell computers, then the real Apple could, based on their trademark, tell me to stop doing this because they have the trademark, which is an absolute right. And yeah, I do not have a comparable right. Like I don't have a company, I don't have a trademark. My name is not Apple, so I would have to cease using this domain. So yeah, this was as fast as I could go.
Thank you, Kai. Thank you very much. Yes, so we don't have so many time. Actually, we don't have time anymore for a Q&A. There is no in the chat box. Maybe we ask for one quick question if someone still has something in mind. Otherwise, I just want to thank you, but just wait a few minutes to see if there is someone raising his or her hand. Matula, maybe very, very quick.
Okay, I try to be as quick as possible. So the question is here that there is a company with the same employees. They want to do 2 lines of business. For example, one is designing and another thing is business consulting. Is it possible to do both with the same employees at the same time, or he is or she is supposed to register 2 companies because they each have 2 different names, 2 websites, and 2 services?
This answer is very quick, very easy. You can operate in different business, in various business fields under the same company. You can also have different names. It's only one company name, that's clear for the legal entity, but you can have like branches which have different names. It's just like on every official paper, like an invoice, for example, and on your website imprint, you need to always have the formal correct name of the company.